Over the last few days, the Supreme Court has been witness to a very peculiar controversy with judges recusing themselves from hearing the case of Gautam Navlakha. Now, Gautam Navlakha is an academic who has been accused by the Pune police of having Maoist connections and being involved with the Bhima Koregaon violence, which has seen obviously many academics, activists and academicians arrested. Now, in Navlakha's case, he had filed a quashing petition in the Bombay High Court where he requested that the case against him be quashed, the FIR against him be quashed. But the Bombay High Court rejected this on 13 September. He then approached the Supreme Court of India asking for this to be overturned. However, when the matter first came up for hearing on Monday, 30th September, the Chief Justice of India, Ranjan Gogoi, decided to recuse himself from the matter. The matter was listed again the very next day before a bench of Justices Ramana, Gavai and Subhash Reddy. And very surprisingly, even they decided to recuse themselves. And not just one judge, all the judges decided to recuse themselves. The matter was then posted for Thursday when it was heard by Justices Arun Mishra, Vineet Saran and Justice S. Ravindra Bhatt, who is one of the new judges who's come to the Supreme Court. And again, this time Justice Bhatt decided to recuse himself. So that's a total of 5 judges in 4 days deciding to recuse themselves from this case. Now, the matter was finally heard today by Justices Arun Mishra and Justice Deepak Gupta, who have now posted the matter for further hearing on the 15th of October. In the meanwhile, however, the question which we have to ask is why were so many judges recusing themselves from this case? And what is the broader issue at play here? Well, I mean, the case itself is obviously controversial. Navlakha initially, in fact, the Bombay High Court found that there was no material against him and would perhaps have ruled against the police in this matter, except for the fact that right at a very belated stage, the government submitted information in a sealed cover to them, which then suddenly changed their mind. Now, there is a lot of political issues at play here with regards to dissent, with regards to whether or not this kind of ideology can be accepted. So, obviously, this is a sensitive case. But is that enough to force judges to recuse themselves? Well, the problem is we don't really know, because none of the judges have actually specified why they felt there was a need for them to step away from this matter. I mean, at least we can presume maybe with CJI Gogoi that it was because he's hearing the Ayodhya matter. With Justice Bhatt, we're hearing that he knows Navlakha personally. But what about the other 3? We don't know. And even for either Justice Gogoi or for Justice Bhatt, they have not given any reasons to us for why they decided to recuse themselves. This is not something new. The court has done this multiple times. In fact, there was a case back in 2017 where 6 judges recused themselves with none of them giving any reasons for this. Now, the danger of this kind of recusal without reasons was highlighted earlier this year by Advocate Surit Parthasarathy from Chennai. Now, he pointed out, for instance, in the Nageshwar Rao case, how judges kept doing this, but even there, at least they gave some oral reasons, if not written reasons. He still said that written reasons are crucial. So, why is that the case here? Well, the idea is obviously that judges are supposed to be, as we know, above question. They're supposed to be impartial. There should be no doubts whatsoever about what's going on with their decision making. But if you have a situation where a judge is walking away from a case and not telling you why, that starts to raise doubts over it. And this is not just something which I am saying or some other advocates may be saying. This was something which was highlighted by Justice Kurian Joseph in his concurring opinion in the NJAC judgment in 2015. Now, he talked about a number of things which he said a judge needs to obviously live up to. And he said that one of the reasons why recusal reasons have to be given is because transparency is key. And I'm going to read out a small quote from that, where he said, ultimately, the question is whether a fair-minded and reasonably informed person on correct facts would reasonably entertain a doubt on the impartiality of the judge. Now, in this case, when you don't have transparency, those kind of rumors start abounding. And that's what we're seeing now over the Gautam Navlakha case as well. And that's not a good thing, because that's the last thing we want for an independent judiciary and for the integrity of the institution which we have. So, what we are seeing here is that Justice Kurian Joseph gave a number of reasons why he felt this was important for judges to do so, and we have to say we have to agree with that, because honestly, we want a situation where the integrity of the institution is not being questioned, and we also know why sensitive cases are not being heard by judges. So, there are unfortunately no rules which require a judge to do this, but we can only hope that this becomes a best practice going forward to prevent any damage to the institution.